6th of May 2023, in the Supreme Court of India, petition will come up challenging promotion granted to 68 Gujarat lower court judicial officers, including Surat Chief Judicial Magistrate Harish Hasmukhbhai Verma, who convicted Congress leader Shri Rahul Gandhi in a defamation case. Now, petitioners are Ravi Kumar Mehta and Sachin Pratap Rai Mehta, senior civil judges, have challenged the promotion of the 68 judicial officers, alleging it was done disregarding merit cum seniority principle. Wherever there is a Congress, there is an invention, and today's collegium is a gift given by the then Congress government and the leader Mrs. Indira Gandhi. Now, this was the first case, judge's case was SP Gupta versus President of India, which was decided on 30th December 1981. This matter, issues involved in this matter were manifold, and main issues were, in this case, was constitutional validity of the order of central government of non-appointments and transfer of judges. 6th of May 2023, in the Supreme Court of India, petition will come up challenging promotion granted to 68 Gujarat lower court judicial officers, including Surat Chief Judicial Magistrate Harish Hasmukhbhai Verma, who convicted Congress leader Shri Rahul Gandhi in a defamation case. Now, petitioners are Ravi Kumar Mehta and Sachin Pratap Rai Mehta, senior civil judges, have challenged the promotion of the 68 judicial officers, alleging it was done disregarding merit cum seniority principle. Wherever there is a Congress, there is an invention, and today's collegium is a gift given by the then Congress government and the leader Mrs. Indira Gandhi. Now, this was the first case, judge's case was SP Gupta versus President of India, which was decided on 30th December 1981. This matter, issues involved in this matter were manifold, and main issues were, in this case, was constitutional validity of the order of central government of non-appointments and transfer of judges in the High Court for a short term. The second issue in this matter was the letter of disclosure of communication between the Minister of Law, the Chief Justice of the Delhi High Court, and the Chief Justice of India was also in question. The third was the issue in this matter was locus standi of the petitioners, and another important issue was the independence of judiciary and the procedure for appointment of judges in the higher courts. Now, this gave birth to today's collegium, and previously it was the prerogative of President of India to appoint judges in the higher court, but after this a collegium was born, system of collegium was born, and it was recorded in this matter. See what judiciary was facing in those days, and it was recorded. It was a majority judgment, 4:2, I think. It is said in the judgment that there must be checks and controls in the exercise of every power, particularly when it is power to make important and crucial appointments, and it must be exercisable by plurality of hands rather than be vested in the single. It is further recorded that it is perhaps the reason why the constitution maker introduced the requirement in clause 2 of article 124 that one or more judges of the Supreme Court and the High Court should be consulted in making appointment of a Supreme Court judge. But even with this provision, it was observed by the 7 judges bench that We do not think that the safeguard is adequate because it is left to the central government to select any one or more of the judges of the Supreme Court and of High Court for the purpose of consultation. We would rather suggest that there must be a collegium. So now in 1981 there was a birth of collegium to make a recommendation to the president in regard to appointment of a Supreme Court or High Court judge. The recommending authority should be more broad based, and there should be consultation with wider interests. It was stated in this judgment that if the collegium is composed of persons who are expected to have knowledge of the persons who may be fit for appointment on the bench and of qualities required for appointment, and this last requirement is absolutely essential. Looking at the history of appointment as such, the CJI is appointed via roster system, and the next in line is the senior most judge till he remains in office till the age of 65 or till he is impeached. That is the provision. Now there were two supersession during Congress time, that is during Mrs. Indira Gandhi's tenure. In 1973, Justice A.N. Ray was appointed, superseding three senior judges, which is due to Keshavanand Bharati's case, which we celebrated 50 years now, in which the pith and substance, doctrine of pith and substance, that the fundamental principles and the basic structure of the constitution cannot be changed. So this was the first supersession, and secondly in 1977 Mirza Beg was appointed as Chief Justice, superseding Hans Raj Khanna, who refused to say that the fundamental rights of the citizens of India is suspended during the emergency. He was the lone dissenter and he resigned. So let us see now what happens. This is the history of our collegium and why it was born.